Today on NBR's Toil and Trouble slot, I'm talking to Senior Associate in the Employment Law team at LegalVision, Gerard Elwell. And Gerard, sexual harassment. Now, some new moves in that area. Tell us about that.
Yes, thanks, Dita. There is a bill before Parliament. It's currently in the Select Committee stage. They're due to report back by the 18th of November. And that's a bill to extend the time available for people to notify an employer of a personal grievance if it's relating to sexual harassment. So specifically that, currently the time frame is quite strict. It's 90 days, which an employee has to raise a personal grievance from the time that the matter arose or that they became aware of the matter. So that might sound like a reasonable amount of time, 90 days, but that time can actually go quite quickly. Sometimes people are quite disturbed or unhappy or upset about the way their employment ended and some of the things that have gone on, and it can take a while for them to seek help and seek advice and get guidance on where to go. So there are a number of clients who miss out on filing their personal grievance within those 90 days, and this bill is trying to address that within a specific area of employer malfeasance.
Right, yes. Is there a sense that people who suffer sexual harassment in the workplace aren't sort of given enough leeway to bring their cases in? Is there a sense that they're on the back foot?
I think so. I think in terms of the time frame, it's quite strictly enforced. So it's actually set out in the legislation, 90 days, and the only exceptions are a provision for exceptional circumstances. And again, that's quite strictly interpreted. So, for example, it was difficult to claim COVID as an exceptional circumstance. So most of us would think that was a very exceptional circumstance, yes, which sort of upset people's equilibrium and their ability to communicate and to process things. However, the interpretation from the courts is generally if you were physically unable to make the claim. So that might be, for example, if you were in hospital or had a serious illness which prevented you physically from making the claim. There haven't been exceptions drawn for issues around depression or stress. And generally the 90 days has been regarded as a sufficient amount of time. So that is problematic. And I think that certainly in the cases of sexual harassment, alleged sexual harassment, there are issues around the time it takes someone to process and even recognise perhaps what's happened and come open up to family and friends, seek professional help, and then perhaps latterly seek legal advice on what their options are. So that time frame, the proposal is to extend it to 12 months, which does allow a bit more leeway there.
Are there anything else? Are there any other sort of ways in which sexual harassment could be better dealt with legally in the workplace, do you think?
It's a challenging one, and there is potential for criminal proceedings in the case of sexual harassment or other forms of harassment. It is unlawful, quite outside of the employment relationship. So there is the opportunity to pursue that. Again, there are barriers, and people sometimes are reluctant to come forward and make a claim because it places them in the spotlight, and they can sometimes feel re-traumatised by the process. But there certainly is a legal process outside of the employment environment. However, that's a criminal process, and so the thresholds are quite a lot higher for getting a conviction or being likely to get a conviction, as opposed to the civil matter, which would be a claim against an employer for sexual harassment or other harassment occurring in the workplace.
And just finally today, probation periods, another hot topic that we often discuss. Now, what's going on with this next case?
Yes, so this is a case of Farrand Orchards and Michael Tane. So that was in the employment court this year, and the judgment came out in July, and it was regarding the validity of a 90-day trial. And most people will be aware of 90-day trials. They may have them in their own agreements, or they may have used them. But what people might not be so aware of is that they are very strictly interpreted, and there is a requirement to follow the process pretty much by the letter, or run the risk of it being challenged and the provision being found to not be valid, and therefore someone may have a claim. So just to backtrack a little bit, people may generally be aware that a 90-day trial provision allows you to terminate employment within 90 days, and it is pretty much for any reason, and there is a lot of controversy around that. It was initially for all businesses, and then it was reduced to businesses with fewer than 20 employees. Right. So So there's a narrow scope there for small, medium businesses to engage people, but because it effectively bars employees from pursuing their legal rights, which is raising a personal grievance for unjustified dismissal, the courts have taken a very narrow view of allowing any flexibility around breaches of the employer's obligations there.
Right. So what happened here in a nutshell? The employer tried to get rid of this guy under the 90-day trial period, and they did it wrong.
Yes. And some of the key things here I think are worth employers noting, because this is something that comes up a lot in practice, and there's a lot of cases and a lot of awards against employers for them failing to meet the terms, the legal obligations there. So some of the things that the employment court found were that there was insufficient evidence that the 90-day trial had been discussed before the employment started.
Right.
So that's one of the key things. One of the key takeaways is that employers must discuss and advise, discuss and bring to the attention of their prospective employees that a 90-day trial will be one of the conditions of employment. So that wasn't done in this case. There was a dispute around what was said in the conversation, but there was no written record of the 90-day trial being a condition. And Mr. Tane actually moved cities to commence work, and he relied on that basis, and he said he wouldn't have done that if he knew there was a 90-day trial provision.
Right.
So there wasn't what the court decided was accord or an agreement around the 90-day trial.
Okay.
He didn't sign his employment agreement before he started, and
Yikes.
the net result was that the company had $15,000 compensation awarded against them that they needed to pay Mr. Tane for humiliation. 3 months lost wages, which was nearly $18,500, and $1,500 in holiday pay and costs, as we talked about earlier. So quite an expensive mistake to make. And the key aspects that employers really need to be aware of is that they need to discuss this before employment commences. They need to make every effort to let the employee know that it will be a condition of their employment, and we would recommend that that's put in an offer letter. And then they must have that employment agreement signed before the person starts work. If they don't, then the courts are going to be very strict in their interpretation and likely find against them and find that the 90-day trial is invalid and that the person does have a right to pursue a personal grievance for unjustified dismissal.
Wow, that's a really good lesson. Thank you very much for coming in and talking to us about it.
Thank you, Dita. Thanks for the opportunity.